Hello, my name is Thorne Barasa, the president of the ICJ in Gluns, and this is the introduction to the ICJ. So you will ask yourself, what is the ICJ? Well, the ICJ in full is the International Court of Justice, and it is the primary judicial organ of the United Nations. That is the world's highest court in resolving disputes before, or rather concerning, states. Therefore, the ICJ is not a human rights court. The ICJ is not the ICC, which is the International Criminal Court. No. The ICJ is the UN's court, and the UN deals with states. So when one state wrongs another state, that is where the ICJ steps in. Not only that, but also the ICJ gives advisory opinions. However, we shall go into this as we talk about the functions of the ICJ. So for now, let's talk about three things: what it does, who can use it, and how it differs from other courts. As previously stated, the ICJ resolves legal disputes between sovereign states and provides advisory opinions to UN organs and agencies. A dispute is very easy. State A wrongs State B, and so State A and State B have an agreement, or State A and State B have a treaty to which both of them are parties to. Therefore, State A having wronged State B will take the case to the ICJ. What is an advisory opinion? An advisory opinion is a legal opinion from the court on a subject that is being discussed by a UN's body or a UN agency. For example, the World Health Organization is thinking about how to handle the current pandemic, and a resolution has been passed. But there is the potential that that resolution might violate another treaty or might violate another law. Therefore, the ICJ steps in and gives an advisory opinion on what the agency or the UN body should do. So that is exactly what the ICJ does. Who can use it? As I stated before, only states can appear before the ICJ as the parties in the contentious cases. Individuals, corporations, companies, and NGOs cannot appear before the ICJ. Lastly, how does it differ from other courts? Well, the ICJ operates at the international level. It is like a domestic court, but for nations, applying international law and not national law. So the two key differences are: one, it operates at the international level, not at the national level. The ICJ cannot decide national matters. And two, the applicable law is international law and not the national laws. Therefore, the ICJ will not apply the Constitution of Kenya in solving a matter. Let us move along to a little bit of history, because I love history, and the ICJ is a very historic court. So pre-20th century, there was no permanent international court, and disputes between states are normally settled through diplomacy, or in the situation where it escalates, it turns into an armed conflict. So that's when you'd have conquest, you'd have countries and states going to war against each other in order to solve disputes. But in 1920, the Permanent Court of International Justice was established under the League of Nations, and it was a landmark step towards institutionalized international justice, because this is the first time we had a court to do with states. Now, between 1939 and 1945, that is during World War II, the League of Nations collapsed, the PCIJ stopped functioning, and the international community sought stronger institutions. That's when we started having discussions about the United Nations and everything. And in 1945, then the ICJ is established under the UN Charter. This replaced the PCIJ, continuing its role in the new UN system. And post that, from 1946 onwards, the operations began. And the court is seated in The Hague in the Netherlands, which is the Global Center for International Law. Now, let's look at the legal foundation and the functions of the ICJ. The Statute of the International Court of Justice is the court's functional handbook or the court's functional rulebook. So that is, we shall call it for the purposes of this class, is the ICJ statute. So the ICJ statute is the rule book of the court. You see how, for example, you have the Constitution of Kenya here in Kenya. Now the ICJ has the ICJ statute, and it governs who may bring cases before the court, what type of disputes the courts might hear, the legal principles that the judges will apply, and more importantly so, the court structure and its procedures. So let's look at the functions. First and foremost, the ICJ solves contentious cases involving states. One state brings a case against another, and the court issues a binding judgment that is binding to these two states. We have very many cases. For example, the Corfu Channel case, the North Continental Sea Shelf case, Nicaragua versus United States in 1986. So there's various cases, or rather there's various cases before the ICJ. As I said before, too, it offers advisory opinions. And these are legal opinions requested by UN organs or specialized agencies. Now, the thing about advisory opinions is that not legally binding, but they carry relevant authority. What does this mean? You will not enforce this advisory opinion over another state, but you can use it to help you make an argument, especially when you've brought a claim, and this we shall discuss later on. Moving along, just to finish, we'll look at the institutional features of the court and the importance. So first and foremost, the court has 15 judges elected jointly by the UN General Assembly and the Security Council, and they are supposed to serve impartially. I understand there's the question of, wouldn't the judge just want to advance the interests of their own state? But the judge is an officer of the court with a task to uphold justice. Therefore, these judges are supposed to serve independently and impartially. And the judges serve 9-year renewable terms staggered to ensure continuity of institutional knowledge on the bench. The reason as to why this is important is so that you don't have very old judges staying on the bench just in the name of experience. But at the same time, we also don't have very inexperienced judges having a shot at the bench. Therefore, there is the recycling to ensure that institutional knowledge is maintained. And the court is seated in The Hague in Netherlands, which is widely recognized as the hub for international law and justice. And the importance of the ICJ is it embodies the rule of law. That is, the principles that disputes should be settled through law rather than force. Because remember, the ICJ comes about after the Second World War. And as I told you guys before, pre-1920 and even post-1920 to some extent with World War II, where diplomacy failed, countries would resort to armed conflict. And so the ICJ stepped in and said that issues ought to be solved through law and not through war. So therefore, the ICJ is an international extension of the rule of law to all states, as all states mandate that the rule of law in their individual borders should be maintained. ICJ ensures that international law within the international borders is maintained. And with that, guys, that is the history and the introduction to the ICJ. See you on the next one.